Ladies and gentlemen, welcome to the second part of our event. And second part means also that we're looking at the second report of the Jubilee project. It's the report that deals with the economy, economic part. And it deals with important questions. How can non-contentious court procedures be better measured in terms of efficiency and effectiveness? What are possible social and economic benefits of outsourcing non-contentious procedures? And how to measure these benefits? What kind of indicators can be developed? And what profits can be gained if the role of notaries is expanded? And to hear the answer of these questions, I would like to welcome from the Economica Institute, Mr. Christian Helmenstein.
Thank you very much, Mr. Kraker, for your kind introductory words. Esteemed presidents, ladies and gentlemen, it's a great pleasure for me to be here this afternoon. Of course, as economists, we are a pure statistical outlier. And thank you very much for having us here nevertheless. Yes, we are talking about the economic perspectives on notaries as court commissioners. Let me give you a brief overview on what we intend to share with you in the next couple of minutes. First of all, I would like to address the geographical area which we have scrutinized. Then I would like to share 4 different dimensions of legal statistics with you, namely efficiency, quality, accessibility, and innovation. We will draw in particular upon 2 different dimensions, namely efficiency and accessibility. And then let's move on from the statistics domain to the economic domain in the narrow sense of the word. And finally, let's derive some policy conclusions. So let me start with the territorial coverage, which of course, as is in line with the hexagonal definition, covers the Czech Republic, the Slovak Republic, Slovenia, Croatia, Hungary, and Austria. As a case in point, to conduct our analysis, we selected the succession process. Before, of course, we heard that there are many other possible fields of notaries acting as court commissioners. We wanted to study this specific field of expertise and thematic area. This chart shows you that there is some heterogeneity available across the 6 countries under investigation, with a different degree of involvement of notaries, ranging from Slovenia to Croatia, the Czech Republic, and the Slovak Republic. As we have heard before already, in Slovenia, notaries do not act as court commissioners in the context of the succession process. Whereas in Austria, we pursue a hybrid system where we need an interface between the activities of notaries and the court. And on the very other end of the spectrum, we have Croatia, the Czech Republic, and the Slovak Republic, where notaries can resolve the entire process. From an economist's point of view, some heterogeneity is always beneficial for a simple reason. Namely, if there is some degree of heterogeneity, you can conduct a peer review. That is, you can learn from the others. Yeah? If everything would be homogeneous, there would be nothing to be learned. Yeah? So some degree of heterogeneity is advantageous. However, the question is this an optimum degree of heterogeneity? And from our point, probably that will not be the case if we look at Slovenia. And let me show you the evidence why this may not be the optimal degree of heterogeneity which we are dealing with. And to do so, first we conducted a statistical analysis, and I would like to focus now on 2 dimensions, namely efficiency and accessibility. So let us start with pure statistics. What is the number of succession cases per 100 inhabitants in the 6 countries under investigation? This is kind of plausibility measure. It's a little bit above 1 if you relate it to the number of inhabitants, which is 101 here. It must be that way because of mortality rates. Yeah? If life expectancy is 70 years, 80 years, then this figure necessarily must be between 1 and 1.25. Otherwise, something would be wrong with the data. So that was the first instance of quality control we applied here to make sure that the data we are operating with are reliable. Now, let me proceed with some more meaningful data. First, disposition time on the left-hand side of the graph. You see that disposition time is very different across countries and depending on thematic area we are talking about. We have highlighted here the area of succession cases in orange. So this is what I'm going to focus on now. And if I said before that Slovenia is a kind of outlier here, you see that it's exactly reflected in the extent of disposition time. Yeah? The notaries in Slovenia are not involved in succession cases, and this is being reflected in a lengthy disposition time. Disposition time defined here as the number of days you'll need after the turn of the year in order to resolve the pending cases. And you see, we have a widespread diversity here between approximately 100 days to solve the unresolved cases from the turn of the year until approximately 180 days. Yeah? So Slovenia is performing worst in this context. And of course, this may be the case because there is no involvement of notaries as court commissioners. A first indication that the involvement of notaries may be beneficial in terms of efficiency and effectiveness. Let us turn to the other chart on the right-hand side of this picture, the clearance rate. Clearance rate means are courts or are notaries able to deal with the number of incoming cases given the speed of resolving pending cases. And of course, this rate must be below 100%. If it is not below 100%, you would see a permanent build-up of backlogs of unresolved cases. Yeah? Fortunately so, we see for all the 5 countries under scrutiny here that the rates are very close to 100% or that they're below 100%. A very positive point here is Czechia. Czech Republic has a clearance rate far below 100%. That means right now they are shortening the number of days, the period necessary to get rid of pending cases. So that's the first dimension. Let me proceed with the next one, namely accessibility. Can legal services easily accessed by the population? On the left-hand side, you see the number of people in thousands per court. That is, figures are ranging from 75,000 people in Slovenia to 123,000 people per court in the Czech Republic. It's a huge dispersion. Austria is at the very lower end with about 64,000 people per court. Interestingly, if we contrast this finding now with the average number of cases other than criminal cases that are handled per first instant court, then we see that we have an enormously large workload with the Austrian courts. Whereas at the other end, we see the workload of the Hungarian courts. That is, there is no systematic relationship to be found here between the average size of the population per court on the one hand and the average number of cases handled by these courts. I think it's straightforward. Naturally, you would expect that there is some relationship, but obviously it doesn't exist. And why doesn't it exist? Because there are different implementation schemes in the individual countries, namely which cases have been transferred to court commissioners in the form of the notaries or to other outside actors in order to discharge courts from their workload. So this would be a second indicator that we should reflect upon enhancing the efficiency of our legal system by discharging courts from specific tasks. But this was only, let's say, the kind of primer, a beginning statement. If it comes to accessibility, accessibility doesn't take place in the abstract space of virtuality. If we talk about highly sensitive issues, usually we are dealing on a face-to-face basis with each other. And then the question is, are courts or notaries are really accessible by the population on site, physically accessible in terms of driving time, for example? Here, on the left-hand side, this chart shows you the population per court on the NUTS 3 level. I'm not sure whether you're familiar with the NUTS structure of the European Union territory. We have the NUTS 1 level, which is usually nation states, the NUTS 2 level, which is usually provinces, and in the case of Slovenia, it's the entire country, of course. The NUTS 3 level is the level below, and then the NUTS 4 level is cities and municipalities. So we are operating here on the NUTS 3 level, which is a kind of aggregated up level of municipalities and cities. And you see that we have an extremely wide range of population within each NUTS 3 unit. Whereas on the other side, we see that the availability, the spatial availability of notaries are extremely evenly distributed across space. In order to visualize that, we have created an animated chart. I'm going to start this chart in a second. So what you see here is a three-dimensional visualization of the population distribution on the NUTS 3 level. And what you will see next, once I have started the animation, is how this enormously large dispersion will be reduced if we compare population to inhabitants. And you see that we'll have notarial services being ubiquitously available across the hexagonal territory. So this is the population distribution on the NUTS 3 level. And now this is the distribution of notaries. And if we rescale this, then see that the degree of the dispersion between the accessibility of notaries and the degree of dispersion of the population density is 60% less in the case of notaries. So let me restart once again, that you see it once again. So this is the distribution of the population, and this is the distribution of the notarial instances. And if we rescale this, you see that this is much more evenly distributed than the distribution of our population across the European Union. And of course, we could formally prove this as well. On the right-hand side, you see a kind of histogram that shows you that population is extremely dispersed because it varies on the NUTS 3 level from 20,000 per NUTS 3 unit to 1.9 million inhabitants, which is the city of Vienna. Yeah? So this is an extreme degree of dispersion. Whereas here on the right-hand side, you see that the distribution of notaries across the European Union territory is much more even. So far, I've been talking about the statistical dimension of courts and notaries acting as court commissioners. So let me now turn from the, let's say, quantitative statistical dimension of the analysis to the economic analysis, because there's something missing something very essential. Economics is not about the quantitative dimension only. Economics is about costs as well. Yeah? So a quantity component and a cost component taken together. Only then it's possible to talk about welfare. So let me proceed now with the economic analysis. Based on Eurostat data, we have just represented here the share of public legal expenditure relative to overall public expenditure. And what you see here is that you don't see a systematic relationship. That is, some of the hexagonal member countries feature a high share of public legal expenditure in overall public expenditure, such as Slovenia, Hungary, and Croatia, whereas Austria is on the other end with a rather low share of legal public expenditure in overall public expenditure. So there's no systematic relationship. Even if you control for other exogenous variables, you will not find a different picture. But there is some other highly interesting relationship, namely the relationship between public and private legal expenditure. And what you see here is that if you relate these two dimensions to each other, that is public legal expenditure to private legal expenditure, and you regress one on the other, that you see that the regression line is negatively sloped. That means that we have a trade-off relationship here between public legal expenditure and private legal expenditure. This is extremely important to understand. The costs for legal certainty are not gone. The only question is who is going to bear them? The public? Are they being transferred in the form of social costs, or are they being transferred to the private people? Yeah, so that's the trade-off here. Public versus private expenditure. The costs are not gone. So they have to be allocated to somebody. And when we talk about efficiency now, then it's not about talking about who is delivering what and who is bearing which costs, but we are talking about moving this regression line in the direction of the origin of the coordinate system. That means enhancing efficiency. That is, if the costs for private participants and public participants in our legal systems are diminished, are lowered. That is the definition of efficiency. That is what we are all striving for, is keeping this trade-off. This is to be decided on the national level, how this allocation will take place. But what we are all striving for is to drive down this regression line towards a higher degree of efficiency. So, if this is the objective we have, the question is, how can we implement this? And from our point of view, it's very important that we come up with appropriate indicators. We have enlisted 13 indicators altogether here, which we recommend that they should be systematically collected. Let me stress here that CEPESH is doing an excellent job by providing already certain indicators. Yeah? And what we recommend is just how they can be enlarged or improved somewhat in order to be even more focused on specific questions and even more helpful. But this notwithstanding, there we have already a highly valuable set of indicators. And what is most important is that we include these indicators and those from CEPESH in the justice scoreboard in the future. Because what we do not monitor cannot be improved in terms of efficiency. And this is our joint endeavor, to enhance efficiency. Here you see the 4 dimensions which I mentioned before: efficiency, accessibility, quality, and innovation. And in all these categories, we propose specific indicators. I think for time reasons, I'm not going to enter into details here. Anyway, you find them in the book as well. And after my talk, of course, we'll hear something about digitalisation in the notaries. And you see that we, in the field of innovation, propose that we should have some indicators that measure, that reflect the degree of digital presence of notaries and other legal actors also in our statistics. So the conclusion is, First, I think I could give you some empirically evidence-based indication that the field of succession proceedings is apt that we should strive to extend the involvement of notaries, because that may contribute to efficiency, because it will move downwards this trade-off between public and private legal expenditure. Then, as mentioned before, CEPES does a great job in collecting data. What we would like to recommend here is to enlarge the data set, to include the findings in the Justice Scoreboard, and in particular, to add in some new indicators, and to associate responsibilities, institutional responsibilities, to the individual indicators. So far, they are not available. And our third request will be, due to a lack of indicators, of course, it's very hard to measure, to track progress in terms of improving efficiency. But once we have the necessary indicators, and once we monitor closely what is going on, then sooner or later we will be able to conduct cost-benefit analysis as well. And only by conducting cost-benefit analysis, we can take optimal decisions when it comes to solving this trade-off, who shall do what, because that is the result of cost-benefit analysis, typically. So let me conclude. I think essentially we are talking about trust. When it comes to the relationship between public institutions, notaries, and the client. And we believe that if we can take evidence-based decisions on how to improve our decisioncy, on whom to allocate which task, that will enhance, that will strengthen trust, and thereby also help that we'll see the rule of the law persist. Thank you very much.
Thank you, Mr. Helmenstein. He just mentioned that one important practical part of this project is digitalization. A task force has studied potential developments for digitalization in succession cases and procedures, and both at cross-border and at national levels. And to hear about the results from this task force, I'd like to invite Verena Nothegger to speak to us. She's a notary candidate from Austria.
I'm delighted to be here and to present the findings from the Task Force on Digitalization. The task force has analyzed which information and communication technology systems, in short, ICT systems, are currently in use in the hexagonale member states, and we've developed proposals for the improvement of workflow, specifically in succession procedures, always keeping in mind the goal of making the procedures more efficient and shortening procedure duration, and thus also strengthening the rule of law, the right to a fair trial. In all hexagonale member states, the digitalization of notarial work has come quite far. We have electronic access to land registers, to company registers, and other such registers. Digitalization, digital communication with the courts and filing of motions in a digital form is possible in most court proceedings, in most countries even mandatory. However, in all member states of the hexagonale, succession procedures are still conducted in paper. Why is that? Notaries are mostly acting as representatives of the court, as court commissioners, as we have heard before. As court commissioners, the notaries are charged with conducting basically the entire probate procedure. That is a well-established system, and as we've heard before today, a pillar of non-contentious procedure. As court commissioners, notaries have access to the court files for a specific succession procedure. But, and here we encounter the root of the problem, we have access only to the paper files, even though there is an electronic file, and as court commissioners, we should have access to these files. This results in a loss of efficiency, also in long procedure durations, and especially in cross-border cases, and even conflicts of competence. That has to change. Notaries need to be given access to the electronic system of the judiciary in cases where the notary is the competent authority. That is a necessary step towards proceedings efficiency and the digitalization of succession procedures. The The European Commission has drafted a proposal for a regulation on the digitalization of judicial cooperation and access to justice in cross-border civil, commercial, and criminal matters. It will be important that notaries acting as court commissioners are explicitly included in the scope of competent authority of the proposed regulation. In the proposal, the Commission assumes the position of digital by default. It is therefore essential to be prepared to implement a fully digitalized process. The civil law notaries of the hexagonal states are already well prepared and fully equipped to fulfill all their duties in digital form. Electronic communication with the courts, as I mentioned before, and also with the parties is fully established in other legal fields. The systems are used on a daily basis and have remarkably increased efficiency in these procedures. For example, in Austria, notarial deeds, general assemblies of companies, legalization of signatures, all these procedures are fully digitalized already. We have the tools to do the same in succession procedures. However, since the courts won't or can't yet accept digital documents in succession procedures and require notaries acting as court commissioners to physically carry the paper files to and from the court on a daily basis, in reality, we cannot offer our citizens such services in succession procedures. The problems of the analog process in succession procedures become even more evident in cross-border cases. Procedures with a cross-border element take notably longer than purely national cases. That is, if you even realize that there is a cross-border element involved, which is not always obvious. The deceased might be registered as a resident in 2 member states. There might be assets in another member state. Digital tools, such as interconnected registers and platforms for information exchange, could help to avoid conflicts of jurisdiction. The EU succession regulation has been in effect for 7 years, and it should have improved the efficiency of cross-border succession procedures, but the intentions of the regulation are currently not fulfilled to its full extent, because the necessary tools for the efficient implementation are missing. So, the task force proposes the following measures. First, at a national level, to establish a digital interconnection system between notaries and the judiciary. For all notaries acting as court commissioners, that is absolutely necessary. We need to establish a system for the possibility to deliver decisions to parties electronically, be it via a secure electronic mailbox or a platform. Especially those countries where notaries are competent to hand down decisions have identified this issue as highly important and urgent. Efficiency could also be increased by giving notaries access to asset registers, such as, for example, bank account registers. On the European level, we propose to establish a secure digital access point or portal for the exchange of information with all parties involved in a case, which could also be used for oral hearings via secure video conferencing software. The e-Justice portal might serve as a basis and be even further developed. This would enable citizens to be in direct contact with the competent authority even when living abroad. In order to avoid conflicts of competence, we suggest to establish registers of succession procedures, where all succession procedures are registered, and to interconnect these registers EU-wide. This should minimize conflicts of jurisdiction. Courts as well as notaries should be able to access the register and to enter data into the register. In order to do so, it would be useful to develop a system to verify the identity of the deceased or of the involved parties in other member states. Currently, the member states use very different systems of identification: social security number, personal tax number, or just name and birthday. We also suggest to establish a register of European certificates of succession, or ECS in short. Currently, the ECS is a form filled in on paper. With the help of multilingual tools, such as they already exist, the issuing of a digital ECS should be made possible. This would ease the multiple problems that citizens encounter with ECS, for instance, when applying for an entry into the land register in another member state. Frequently, the limited validity of the ECS is a problem. A certified copy of the ECS is valid only for 6 months. Strictly speaking, that is not an issue of digitalization. That is not to say that digitalization couldn't be helpful to improve the efficiency with which an ECS can be applied. The interconnection and direct cooperation between notaries of different member states needs to be intensified and simplified, especially for the transferal of documents and the taking of evidence, but also for obtaining reliable information about foreign law if one should have to apply foreign law under the succession regulation. There are tools currently available through the ENN, as we heard today, and often the information obtained via these tools is very helpful to advance a case. But to get official documents accepted by the courts at a local level, one still needs to jump through the hoops of judicial assistance via notarial chambers, courts, and even the ministries of the exterior. The European notarial network should therefore continuously be taken even further and might also include courts or other competent authorities, taking into account that in all member states a different entity might be the competent authority in a succession procedure. The goal should be to eliminate unnecessary intermediaries, so in order to make the procedures more efficient. First, it is necessary to develop a way of accessing electronically the necessary information for checking which entity or person is actually the competent authority for a specific succession case in another member state. A very important basis for all electronic developments is, of course, the successful implementation and rollout of the e-ID system all over Europe and the necessary recognition in all member states. Same goes for the electronic qualified signatures and electronic seals of notaries, judges, and other court officials. There should be an EU-wide system for checking the validity of these qualified electronic signatures and seals. It is absolutely imperative that we be able to trust the provenance of the official's qualified electronic signature or seal. It will also be necessary to further develop the interconnection of registers of last wills and testaments. We suggest that an effort should be made to include all member states of the EU in the ARERT system. Also, a unified way for the transferal of a last will to another member state needs to be developed when that member state is the competent authority. Advancing digitalization is a very important goal. There are, however, some issues that need to be considered. Not all citizens in the member states have sufficient access to electronic devices and fast enough internet or internet at all. The member states need to make an effort to assist their citizens also financially on the road to digitalization. Otherwise, we are at risk of creating a two-class society. Those who have access to efficient justice and those who don't. It goes without saying that all transfer of documents, tools, and platforms used in judicial procedure must meet the highest possible standard of IT security and data protection. One needs to be able to rely on the authenticity of documents. We have to ensure that we can maintain the trust our citizens put in authorities such as notaries and courts in the European Union. It is important to take care to preserve the role notaries play as court commissioners in succession procedures. Notaries, being independent and impartial, have proven to be an indispensable asset within the system of non-contentious procedure, helping families to find equitable solutions in succession procedures without long and costly court proceedings. The notaries of Europe are also a valuable asset in the age of the digital revolution. The already existing resources and infrastructure of the notariates can be used to further develop digitalization of the judicial system in the field of non-contentious procedure. Any new legislation in the field of judicial process should always keep in mind the requirements of the age of digitalization. It is important to look to the future for possible technical developments and to prepare in time for what is to come. It is also vital to keep in mind the European perspective. After all, digitalization knows no borders. Thank you very much.
Thank you, Mrs. Nothegger.